Good morning, everyone. Welcome. Happy Tuesday for all of you. So I'm Sofia Bahana. I'm the project manager with the Minority Business Development Agency, most known as MBDA. I know it's a long name too, but you can kind of like memorize MBDA better. So we support minority-owned businesses in different areas besides one-on-one business consulting. We concentrate on access to contracts, access to capital, and access to markets. If you feel that you need support on those areas, please feel free to reach out to us or to me. We also have Stephanie here. Stephanie Scott is one of our business advisors. So thank you for being here, Stephanie. And yes, please feel free to reach out to us. Today, we have the pleasure to have our partner, SBDC, Fran Fernandez. So please, Fran, introduce yourself and introduce all the wonderful benefits that SBDC has.
Very good. Thank you. Thank you, Sophia. Good morning to everyone joining us today. As Sophia said, my name is Fran Fernandez. I serve as director of the Small Business Development Center at Central New Mexico Community College, the SBDC at CNM. Just want to take a few minutes to share with you how my organization serves small business owners in the community. The New Mexico Small Business Development Center program was founded in 1989. We've been serving small business owners across the state for 34 years now. We have 18 small business development centers across New Mexico, and we have a highly skilled staff that's comprised of 63 business professionals that have business management experience and business ownership expertise. The New Mexico Small Business Development Center program is funded in part by the Small Business Administration and the New Mexico State Legislature. And we also operate through a cooperative agreement with Santa Fe Community College to provide services to small business owners in our community. My center's host institution is Central New Mexico Community College, CNM. We proudly serve our clients located in our service areas of Bernalillo and Sandoval counties. Our mission is to develop skilled entrepreneurs and strong businesses in our state. The Small Business Development Center at CNM provides counseling and training services to help small business clients start their businesses, to grow their businesses, and most importantly, to stay in business. Some of our client services include our no-cost confidential business counseling to help clients at all stages of business development. We provide technical startup and assistance to help clients understand the steps of starting a small business in the state. And we work with existing business owners to help them continue to thrive and grow. We also provide business and marketing plan assistance from getting started to reviewing completed plans for client success. We can also review available funding options and help assess the best options for our clients. We do work with many lenders in the community. We can also help our clients access market and industry research as part of the planning process, as we have several tools available. We also offer bilingual counseling and support services to our Spanish-speaking business owners in our community. And, to help our clients become skilled entrepreneurs, we do offer low to no cost business education workshops and trainings through our online training portal. So as you can see, there's many advantages of working with the Small Business Development Center at CNM, as well as our community partner, the Minority Business Development Agency, as we all want to help you and your business succeed. I encourage you all to please visit our website listed there on the screen at www.nmsbdc.org to learn more about our program, or you can register for services online, counseling and training. Or you could just, simply give us a phone call at our main office or email us. We're always available to help you with your business needs. And so with that, I would like to go ahead and turn the floor over to our presenter today. We are very fortunate to have Mr. Jay Bell with us today, and he's going to talk to us about Contracts 101 for business owners. So Jay, take it away.
Thank you very much. Good morning, everyone. I'm glad to be with you this morning to share some insights into contracts and what you can do to sort of help yourselves along the route of operating your business and dealing with customers and maybe joint ventures, people that you want to go into business with and share different ideas and different products and so forth. So we'll just kind of take you through some of the things that I hope you'll absorb so that you can apply them to your everyday business. It's called Contracts 101, so it's going to assume that we're starting at a level of not really knowing that much. Although as business owners and managers, you know a lot more about contracts, than you think you do at the very beginning. It's just because you've been reading them, you may have been drafting some, but in any event, this, obviously this isn't a law school seminar. For those of you that maybe did go to law school, that the contracts course in law school is like a year long, and you go 2 or 3 times a week for an hour and a half, and that's just the basics on contracts. It doesn't even get too much into how to calculate what your damages are if there's a breach of a contract, or whether or not you can actually force someone to perform on a contract in different situations. So we're going to kind of condense this down and give you some of the highlights of things that you can look at or look for when you are given a contract for review, or if you have been asked to put together sort of an initial draft of a contract, then you'll know some of the things that, oh, maybe I need to consider this or that. So you don't need to know everything there is about all of this, but I think if I've picked the right topics, I think it'll give you some tools that you can apply in running your business. So we'll look at the big issues, and again, a lot of these issues will depend on what industry you're in. The construction industry, for example, has a lot of terms and legal issues in it that are completely different than, say, a business that is a retail store. And we can't cover all the differences, but I've picked out the topics that I think apply to all types of businesses. And then, once you get into your specific industry, there are other issues to take into consideration. I think generally, one of the biggest topics is written contracts versus oral contracts. And I've had clients tell me in initial conversations that, well, we don't really have a contract, we just sort of verbally agreed. Well, verbal or oral contracts are enforceable in many situations. There's a whole body of law that deals with contracts that have to be in writing. For example, if you're going to sell a piece of real estate, if you want to have a contract that's enforceable, it's got to be in writing. But I could, come and say, hey, I'll mow your lawn for $1, and you say, great. And then I go mow your lawn and I come back for my $1 and you say, well, wait a minute, I changed my mind. It's still enforceable. So you can have an oral contract that's enforceable in many instances. The problem is you have to prove it. And without a writing, it's very difficult to prove an oral or prove a contract that's only oral, because obviously it becomes, a he said, she said. So that could be a whole nother couple-hour seminar on the differences between oral and written contracts. Let's just all assume written contracts are always better. So, and we'll talk a little bit later about what can happen if you have multiple deals or a long-term relationship with certain clients or customers or other people you're doing business with, things to look out for. But the initial consideration is who's signing this contract. A lot of small business owners have a little bit of not difficulty, but they tend to forget that if they are an LLC or a corporation, that is a separate entity. So if I own a law practice and I'm the only attorney and it's J. Bell LLC, the LLC is the business. I'm just an employee, right? So if I want to enter into a contract with someone, I'm not going to enter into the contract as J. Bell. I'm just an employee of the company. I don't want to be the person that's obligated under this contract. And then a lot of times that's obvious, but sometimes what happens, I've seen clients bring a contract to me and say, hey, I got this sent over. Can you look it over for me? And the initial thing that I see in the very first paragraph is that the party in the contract on our side is the individual. So we correct that. We make, okay, is it your company? Do you have a corporation, an LLC, a partnership, something? That is the entity that's contracting. And then when you sign that contract, you sign J. Bell, comma, member of J. Bell LLC. You're not signing it as J. Bell. You're signing it as a member, as a representative of the LLC. And an example, I had actually went to trial. I had a jury trial, and it was a company, I think it was called Professional Builders, Inc., that we were suing. And they stuccoed my client's house, and it just fell off. It just was a terrible job. So we sued the corporation, and we sued the individual owner of the corporation, because I saw in the documents that although the contract for the job was with Professional Builders, Inc., he used abbreviations later in the contract. He said PBI, and then he signed it just as an individual. He didn't reference his ownership of the company. And then some of the checks that were written to him were just made out to him individually. And we ended up going to trial. We won, and we got personal liability against the individual for the damages. So it's important to maintain that formality. If it's an LLC or a corporation, you want to maintain that formality all the way through and make sure that you're not entering into any contracts individually. People say, well, you know, what's the big deal about written contracts other than what we've already talked about? And people sign contracts, it's more likely that they're going to perform their obligations. There's something in the psyche of people that it's almost like a fence around your yard. If somebody wants to violate your privacy, they're going to hop the fence. But the fence is there, and it creates a psyche in people. Oh, they don't want people coming in, so I'll go around. That is a real thing in agreements, in contracts. And also I just want to mention quickly about letters of intent. You may have heard that term or used those, where people enter into written documents. They sign off on written contracts called letters of intent. And it's basically, hey, I don't know if we're ever going to do this deal or not, but do you agree that these are the major terms? Let's at least agree on that. And it's not binding. You don't have to perform, the ultimate contract just by signing this. It's just an agreement that we're going to agree later. And for example, business brokers use letters of intent a lot because it tends to create this, not an obligation, but an investment in the whatever deal it is, if you're going to sign off on something. So there is a great benefit, other than the obvious ones, to having somebody sign something, even if it's just a letter of intent that's not ultimately binding on anyone. Another thing, obviously with written contracts, it's going to spell out all the important things, right? Like, for example, when you're going to get paid. That's the big one, right? That's what you're getting into all this about. But then it goes further. Usually you've seen this in contracts. Hey, if you're late, if something's due, whether it's a lease, commercial lease, or any kind of situation where you're going to be paying over time, there's usually a section that says, well, what happens if I'm late? Or what happens if you're late? Can I charge a late fee? Can I charge an interest fee? And what's the maximum amount of interest I can charge? If you're late, can I terminate the contract? And if I do that, what does that mean? What do I get if I terminate the contract? Can I terminate and get a penalty? So the whole idea, or the section of a contract that deals with the payment, is obviously really important, and you can really spell out, you know, what's going to happen in case somebody does breach. And you want to know, hey, if something comes up and I breach, what am I subjected to? What are going to be, you know, my obligations? So, you know, it works both ways. And it may be also good to have in your contract when I can and if I can terminate this agreement and under what circumstances. Something may happen that, you know, you want to get out of this. Is there a provision in there that allows me to leave this contract midstream without being penalized? Oftentimes, maybe there isn't such a situation. And what would be the terms if I can terminate? Do I have to wait until I could send a letter to you saying you have 10 days to cure whatever this default was, whether it's a payment or finishing a project or delivering products? Do you want to have a 10-day cure period either for you or for the person on the other side? And it really, it's you're not anticipating someone breaching the contract. It's almost like a prenuptial. We're going to be great. It's going to be a great relationship and everything. But if something happens, we don't have to decide what we're going to do. The contract already spells that out. So, and I was going to give an example of a recent case where there, a couple got building a house, they got a construction loan from a bank and hired a contractor to build the home. Well, toward the end, the homeowner stopped paying the contractor for various allegations and certain reasons that they felt necessary to stop paying. Well, and there's a contract between the contractor and the couple, and they're fighting over that. But what the homeowners didn't realize was in their construction contract, it says that they can't stop paying their general contractor. And if they do, that's a breach of their construction loan. And the bank filed suit and foreclosed on the construction loan, not because of what was happening between the two of them, but because of what was happening between the homeowners and the general contractor. So they were obviously not aware of these triggering provisions in their construction loan. So termination of an agreement can oftentimes be affected by something that's done to a different party. And that's, in the construction industry, like I said, when you get into specific industries, there's all kinds of cross sections of obligations and duties. Written contracts also allow you to establish warranties, indemnities, and liabilities. This is what I want. I'm hiring you to do something. I would like you to warrant your work. If somebody sues me because of what you did, I can come after you for indemnity for this, for damages to this third person who got hurt by what you did. And what are the liabilities of both parties? And you can also use the contract information or language to limit those warranties. Well, I'm only going to warranty this work for 6 months or a year or 18 months. Or I don't warranty it at all. Surprisingly, some of you will think this is crazy, but in a lot of contracts, there's provisions in there that they don't warranty this product for any particular purpose. It's just language like that. And it's like, well, I'm buying this product because it is a whatever. And you're saying that you're not even warranting it for that purpose. So you can actually limit warranties and indemnities in the contract if you use the right language, because the body of law, the courts value people's ability to enter into contracts. It's one of the basic tenets of the law, that people should be able to enter into contracts. There's restrictions and safety nets for people, but the overall general purpose is to let people enter into contracts as they wish. Okay, so another big, I think, important provision that you can either have or not have in contracts, depending on what you want, is an alternative dispute resolution provision. And it's a long word for, hey, if a dispute arises out of this contract, we're not going to court. We're going to go to arbitration. And, why would you want to stay out of court? Certain businesses, and I listed a couple there, insurance companies, banks, general contractors, those, just to name a few, types of businesses do not want to have a dispute decided in front of a jury. Why? Most people don't like insurance companies or banks or general contractors. It's just the fact of life. You can add lawyers in there too. It's just you walk into court for a jury trial and you're representing an insurance company or a bank, and it's an uphill battle because nobody likes banks. Nobody likes insurance companies. So you have a provision in your contract that says, hey, if we have a dispute about this, dealing with this contract, we all agree that we're going to go to arbitration. And one of the most well-known arbitration companies is the American Arbitration Association. They have offices in every city in the world, probably. In any event, it's an informal, more informal trial than if you're in court, and it's before an arbitrator, and an arbitrator makes a decision and it's binding. Everything else is pretty much the same. You just don't have a jury there, and there's some other benefits. It's cheaper. It happens quicker. You can get an arbitration in a case within maybe 6 months, but if you get, you go into court, it could be 3 years before you have a trial. I've polled juries after jury trials and said, well, what was involved in your decision and everything. I've had juries say, well, we just really didn't like the other guy. He was smirking when he was sitting at the table, or, he didn't even dress up to come to court. So he must not have thought it was very important. So sometimes you want a jury, if maybe you're going up against a bank or an insurance company, you may want to have a jury. But in any event, the contract that you receive to review or the contract that you prepare to send out may or may not have an arbitration clause. And you can think through, depending on the situation, whether or not you want to have that. So that's another important thing to look for in contracts, and then to consider if you're preparing a contract. Another big issue in written contracts is ambiguities and vagueness. The more specific you can make your language, the less likely you're going to get embroiled in litigation if something happens, if somebody violates it in some way. Because if there's a breach of a contract, say somebody stops paying or they stop, delivering whatever they're delivering, they may take this contract to a lawyer, and the lawyer is going to look for loopholes to try to determine whether or not they can get their client, out of this bad situation. And they'll look for ambiguities and vagueness in contracts to say, well, it doesn't really say that, we didn't breach this. And litigation costs are a major concern for all businesses. It really can swallow up what it is you're fighting about. And I've had clients in initial interviews, and I say, this is going to be expensive. This is how much you are trying to go after this person for. It's going to cost you, this amount. People, sometimes people say, I don't care how much it's going to cost. I'd rather pay you. I'm not paying that guy one dime. And so this big, the issue of principle, I'm not going to let this person get away with this, and I'm not going to let this person do this to other people. It's this virtuous position, and it's real. Oftentimes, though, after they receive 3 or 4 months of invoices from a lawyer, the principal kind of takes a back seat. Now it becomes more of an economical situation. So if you can have the contract be as specific and clear as possible, you're less likely to go down that road of having to spend all this money to defend or fight a lawsuit, because oftentimes the other side will say, yeah, I messed up, I better get out of this cheap. How much can I pay to get out of this? So it can short circuit things pretty nicely. Other issues in written contracts: establishing confidentiality. How much do you want the other person talking about this deal to other people? Maybe it doesn't matter, and maybe you don't care. But think about it. Maybe you do. Maybe you don't want them to talk to potential other customers about the great deal you gave them, because then they're going to and then you're kind of stuck with prices on certain things. There's non-compete issues in written contracts, non-solicitation issues as well, non-solicitation of employees, and non-solicitation of customers. You may not want the person you're contracting with to be able to do that. Maybe vendor identities are things that you want to keep confidential. You don't want it to get out who you use, because you like who you use, and you don't want them maybe to develop other relationships and leave you behind. In the employment area, that's where you have this non-compete situation. And interestingly, I've practiced law in 3 different states, and I've had clients in all different states make comments to me like, well, I know they're not enforceable. Well, they are enforceable. There's different situations in every state. You have to be reasonable in your restriction, but non-compete clauses are enforceable. So if you're an employer and you're hiring somebody for maybe an executive position or a managerial position, you don't want that person working for you for a couple, 2-3 years, learning your whole system and everything, and then going to work for a competitor. And you don't want that person leaving and then soliciting all of your employees. Hey, come with me. I found a great deal. And you certainly don't want somebody soliciting your customers. So there's some restrictions that can be put in place in writing in an employment situation that can be really valuable and can protect businesses. In joint ventures, where maybe 2 different companies are getting together for one project, and that's it. Just, we're going to work together on this project. Here's the deal, and you have an agreement that spells out what each business is going to do, and who's going to get paid, and so forth. But in that relationship, maybe some confidential internal information is going to be necessarily exchanged, some trade secrets. So you might want to protect against the disclosure of that information, and you can have a provision, or you can have an entire separate agreement for a non-disclosure of information. Hey, we're going to be exchanging all this information. It's going to be great. We're going to make a lot of money, but you can't tell anyone else about this. And oh, by the way, when this deal's done, we're both going to either destroy everything we've accumulated from each other, or we're going to return it. So you can lay all those things out so you don't worry. And if you're buying a business, if you're buying a business, the seller of the business is most likely going to be wanting you to sign a non-disclosure agreement, because you're going to be looking at all their financials, what they've done in the past, how much money they have, what kind of assets they have. So, if you're going to buy a business, expect to be presented with a non-disclosure agreement. And if you're selling one, you want to have one. Another biggie, I keep saying another biggie, they're all big, is usually at the end of the contract, you'll see this, and it'll talk about venue and jurisdiction and choice of law. A lot of people don't really know what that means. What it means is, if a dispute arises out of this contract and you don't have, your arbitration clause, oftentimes it'll say the court that we have to bring our disputes in is in, Albuquerque, New Mexico, and the person on the other side of this contract may be in Michigan. So, and that client, that person's lawyer is going to say, well, we want to have Michigan as being the venue or the jurisdiction. We want to force the New Mexico people to come to Michigan if they want to sue us, because that's a lot harder to do. Get a lawyer in Michigan and all that kind of thing. So companies will jockey back and forth if you're from different states. And the choice of law, you'll see this as well toward the end. It'll be stuck in there at the end. If a dispute arises out of this contract, Michigan law will apply. Michigan law, you don't know what Michigan law is. Maybe your attorney doesn't know what Michigan law is. So there's some negotiation back and forth on that as well. But it's important to note that. You might be fine with it, but you want to know that in advance. You don't want to be served with a lawsuit from a court in Detroit, and have a short time to respond to that lawsuit and trying to catch up and why are we in Michigan and that kind of thing. So look for that, see what it says. Doing business in New Mexico, more than likely, it's gonna be New Mexico. But if you're doing business with companies from out of state, it'll be something to look for. One thing I wanted to point out, because I had a client recently, this is what happened. He had done several deals with a specific person, and everything went fine, and it was always in writing. I got 3 or 4 deals, and they had little contracts. They did them themselves, put these contracts together. Everything was in writing, and everything went smoothly. He got comfortable. They became, not real friends, social friends, but they were making money, and so they got comfortable. They got a little lackadaisical, and they did 2 deals without a writing. And the other side breached both of them, and now they're about ready to get into a lawsuit. And all of a sudden, there's nothing in writing. It's a totally different deal. So guard against becoming comfortable when you do multi deals with the same party. Treat it like it's the first one every time, and you'll sleep better at night. Nothing personal. Sorry, I'm requiring you to sign this agreement, but it's a business deal. And if you were to get hit by a bus, or the other side, the main principal was hit by a bus, someone else is going to stand in, and they need to know what the deal was. So you're doing it to protect everyone. It's not, a personal affront on someone for wanting to have a contract. Some other contract issues that pop up that maybe that may surprise you, maybe not, maybe you've seen these, but there's in most states, in New Mexico as well, there's an Unfair Trade Practices Act, which really has a big sword in it, because if you can prove someone violated, and they spell it all out, and there's like 20 or 25 different things that they consider to be unfair trade practices, you could be, if found liable under that, you could be liable for 3 times the amount of damages. So let's say you did something and the damages were $100,000, it could triple. Plus there's an attorney's fees provision in there. So you could really get, so the caution here is be careful about what you say about products or services in a contract or verbally prior to. Don't oversell, don't over, glorify this, make promises that are, really not accurate. You don't want to blow them up too much, because if they can prove that you were unfair in your trade dealings with them, they could bring an Unfair Trade Practices Act claim. So don't overreach, don't get too opinionated about what you're providing. That's just you could spend 2 hours just on that, but that's just something to be aware of. The next one's really important too. There's something in most contracts, and it's been a long time since I've seen a contract that did not have this, but it's either a merger clause or it says integration clause. And what that means is, hey, whatever we talked about leading up to this is not important and is not part of the deal. The deal is what is in this document. And, the legal terms say, well, the four corners of the document, that's it. If right before you sign a contract, you look at it and you're kind of thinking about one of these provisions and it says something that you don't like, and you bring it up sort of at the last minute, and you say, yeah, I never saw this before. I'm not sure that I like this. And the guy on the other side of the table says, don't worry, we never enforce that. In the 30 years I've been with the company, we've never enforced it. The lawyers just want that in there. So don't worry about it. And so you sign the contract, and then, maybe nothing happens. But 6 months later, maybe that it does happen. And the guy that was sitting at the other side of the table isn't even working there anymore. So the contract gets sent up the ladder, gets to the lawyer, and they say, well, the contract is the contract. And here it says. And you say, well, he told me. Doesn't matter. You could have a recording where he said that, and it doesn't matter. The courts won't enforce it. It's not part of the deal. So just make sure that the written contract reflects exactly what the deal is. And one thing to think about is, if somebody does say that, we never enforce that, that's just in there, then you can say, well, let's write at the bottom, paragraph 7 is taken out or extracted, and you both sign it. Say, well, just make me happy. Let's just sign this right now. We'll just amend this. We'll cross it off and initial it. And sometimes, the other side will just do it, so it's fine. But you can really tell a lot if people aren't willing to do that. There's another provision you'll see sometimes, not always. It's referred to as the drafter's rule. So there'll be technically, from a legal standpoint, if there is no provision in here in a contract that deals with this, then the law looks at if there is an ambiguity or some vagueness. The law will look, well, who wrote this? Because if the ambiguity goes against the person who wrote it, the courts are going to uphold it and say, well, look, it's ambiguous. It looks like it works against you. You could have corrected it. You're the one that wrote this contract. So don't blame the court if we find against you on this ambiguity. So what happens is people put provisions in the contract that says, we've both negotiated this contract. We both have had the opportunity to review it and revise it. And neither party is going to be considered as the drafter of this document. So that turns it into a level playing field for if there is an ambiguity later. and it's made a big issue. It's an important thing. And I can say that I've never had a case go to trial on this issue, but it has really worked in settling cases, because you can point out that ambiguity and that deficiency, and especially when the other side is the side that wrote the contract and drafted it. It makes them scratch their head a little bit and wonder, maybe we better get out of this. Maybe we better try to mitigate or lessen this situation and get out. I've had it happen in an insurance context where, believe it or not, the insurance provisions in the policy were pretty vague. And it happened to be right on the issue that we were dealing with, in whether or not there was going to be coverage. And, I don't know how long they'd been using this particular policy, probably years and years. And maybe it never came up, but it did come up, and the insurance company pretty much reversed course on it. And the case ended up settling, and it was a good result. Attorney's fees clauses. This is really important as well. They're all important. But a lot of times, the attorney's fees that are incurred really subsume and take over the whole matter, because maybe you're not suing for all that much money, or you're not, you're getting sued, but it's not a lot of money, but you don't want to pay it. And then you think, well, geez, it's going to cost me X dollars just in attorney's fees to win this. And then if I win, did I really win? I just paid this law firm all this money. I could have just paid them the $5,000 that they wanted, even though I don't owe it. So you could have an attorney's fees clause in the contract, because in England they call it the English rule. Winner gets their attorney's fees generally. In the United States, the American rule is everybody pays their own attorney's fees, except in certain circumstances. And maybe it's in divorces, in lien actions. There's certain statutes that provide for attorney's fees. But if it doesn't fall into one of those categories, everybody pays their own attorney's fees. So you can put in the contract, hey, if a dispute arises out of this agreement, the prevailing party will get their attorney's fees paid for by the other party. And there's language you can put in: reasonable attorney's fees. But at least that, hey, if I take this the full way, I also stand to get my attorney's fees. And the judge will give them to you. They have to be reasonable. And there's some discussion about the reasonableness of the attorney's fees. But you'll get them. Another thing that you can agree to in contracts, surprisingly, I think, is you can agree ahead of time to subject yourself to an injunction entered by the court against you. And you'll see this language a lot in non-compete agreements with employees. And it'll say, if suit is brought to enforce this non-compete provision, you agree, Mr. Employee, to allow the court to enjoin you or stop you from whatever this activity that you're doing in the non-compete. Saying you're opening your business across the street, and that's a violation, a new business, and that's a violation of the non-compete. You agree ahead of time to allow the court to impose an injunction and stop you from conducting your business pending the outcome of the lawsuit. Well, that could be huge. All of a sudden, you're out of business for 2 years. So injunctive language in contracts is something to be aware of and recognize if you see it. Okay, so I see that we're getting toward the end here, so I'll try to get the rest of this in. We like to propose to clients that they develop some form contracts, and it doesn't apply to every industry. But you can have a form of maybe a page or page and a half of all the legal terms, right? All the things that we've already talked about. And then at the, somewhere in there, you have see Exhibit A for the scope of the work being performed or the products being sold or whatever it is that you're promising to do, the services you're going to give, whether it's consulting or whatnot. So in other words, you have the standard form that you use that has all the legal in it. And then attached to it is the what am I doing? How am I getting paid? What are you paying me? Or what am I paying you? And that changes with every deal. So you don't have to redo everything every time you have a new customer or a new deal. You can just change that attachment because that will be different, whether you're selling products or performing services for someone. And sometimes when you're dealing with some larger customers or clients, maybe the initial person you're talking to is the decision maker, but they're not the person that's going to be reviewing the contract. So it might be the same person, but recognize that maybe it's a different person. And you don't need to go into all the legal details with the initial person because they're just deciding whether or not the deal is going to be made or not. But, it could be the same person, but just, decide that, kind of recognize that when you're going into those negotiations. Part of this is you don't want to, put together a 15-page contract for someone. It scares a lot of people off, especially smaller businesses, because then they think, oh, geez, I just want to, get a contract to do their landscaping for, the next 6 months. And I don't want to, a 15-page document. I have to take it to a lawyer and it's not going to be worth it. Nah, never mind. So, and a good lawyer will recognize that and try to take that into consideration. And I'm trying to think. Okay, so employment agreements. It's a good idea to have employment agreements for people that are, at manager level or above. Keep that in mind because there are some things you want to protect. That initial stage is the honeymoon stage. Everybody's very excited. They're looking forward to bringing on that new person and delegating and letting, if you're the owner, letting this person do certain things. And but you have to remind yourself this is a business deal. Maybe in a year, it's not going to be so happy. And I want to make sure I have my ducks in a row on it. So here again, I'm talking about the, the terms, try to have, a template. The COVID-19 thing, as everybody knows, really brought up a lot of things that had not been dealt with before. And, there's always been these, it's called force majeure clauses in contract that say basically, hey, if something unforeseen comes up that we didn't even know about, it's out of our control and everything, we're not required to do A, B, or C, or we get to have more time to do A, B, or C. And you could see this happen really with COVID in the construction industry because the supply chain was interrupted. People couldn't get supplies, and if they did, it was 3 times as expensive. So contracts now, people are spending more time in that area, making sure that everybody's on the same page as to what might happen. Right? It may never happen again, but those are becoming standard provisions. And borders might get closed down. I mean, all kinds of different things can happen. And non-essential businesses, they really need the help because they're the ones that get shut down first. So I want to leave a little time for some questions, but just generally, now you can maybe recognize what some of these legal terms mean, and it'll trigger you to look into them a little bit more. And if you're dealing with out-of-state customers, that's a trigger. Why? Because of this choice of law provision, right? You want to make sure that it's not that the language is clear. It's interesting if there is some unclear language or vagueness. Who decides? The judge is going to decide. And the judge doesn't know your business, doesn't know the industry maybe. So you want to make sure that the language is written in such a way, not that it could be understood, but that it can't be misunderstood. People use examples. I've seen that, and I've used examples to make sure everybody's on the same page with regard to whatever the issue is. And it's well worth it at the beginning to put the time in so you can sleep at night and not worry, oh, did I forget something? That kind of thing. So with that, I don't know if we have a little bit of time for questions.
Yes, we still have 8 minutes for questions.
Okay. So do you want to just?
There is one on the chat if you can see it on the, sorry, no chat, in the question and the Q&A section.
Oh yeah, let's see. Let's see. I don't see it. It's so small, I can't read it actually on my screen. Let me see.
We can read it to you, Jay.
Yeah, go ahead.
Okay, so it says, hi, I had a question about if a situation would be considered as part as unfair trade practices and enforceable as a verbal agreement, as there was no contract agreed in good faith. The other business did not complete their end of their agreement, and I had paid in full. Thanks so much.
Okay. So it doesn't hinge on whether there's a written contract or not. Okay. But again, but also it doesn't get triggered just because someone failed to perform. You have to go a step further, and that's why these cases are so hard to prove, because especially if there isn't a lot in writing, you have to show some malfeasance on their part, some almost intentional conduct. They knew this wasn't true and they still represented that it was true, that kind of thing. So it's a heightened burden of showing in order to get those additional damages. Now, people bring these claims. Lawyers will allege these claims in a lawsuit, along with just a general breach of contract claim or a fraud claim. They'll bring an unfair trade practices claim because it has such a big sword. And for strategy reasons, let's say a lawyer thinks, well, we have a 50-50 chance. We don't know because we haven't seen all the documents yet, but let's allege it. And then if we can't prove it later, well, then, we don't win on that. But it's often alleged so that it makes the other side pause. Yikes, we might be held liable for 3 times the damages. So you wouldn't want to discount it at the beginning. In fact, you want to allege it and then decide and figure out whether or not you can prove it. It's possible in a lot of different cases. So I hope that answered it.
Excellent, excellent. So there's another question. It says, do you write subcontract agreements? If so, please provide your organization's contact info.
Yes, we do a lot of construction contracts, general contractor agreements with owners, and subcontract agreements between generals and subs. You can go to our website, Law for Small Business, and inquire there. In fact, that's our online presence. We have a lot of flat fee forms and other services on there that you can look over and see if they match up. Or if you want to have a consultation, a 30-minute consultation, you don't even know if you need a lawyer. but you want to talk to a lawyer about that. You can sign up for a 30-minute consultation and just have a chat. So there's a lot of information on the website that you can go to, but the answer is yes, and you can contact us through there.
Excellent, excellent. And there's another one that says, Jay, are you here in New Mexico? And again, the contact information, I think folks are really wanting to contact you. So
Sure. Yes, I am. I work remotely in Santa Fe. Our office is in Albuquerque. And we have two sides to our firm. Law for Small Business is our online presence. And we do a lot of, like I say, flat fee services there, forms people can purchase. You can form LLCs and corporations and that type of thing. And that's law for small business. And then the other side of the firm is